Good day. We are group number 1, composed of Mr. Salvador Santos III, Sheila May Orbe, and yours truly, Pilar Pinga Cruz. We are here to share with you some important facts and information about the National Labor Relations Commission, or NLRC for short. NLRC is a quasi-judicial agency attached to the Department of Labor and Employment for program and policy coordination. It is mandated to adjudicate labor and management disputes involving both local and overseas workers through compulsory arbitration and alternative modes of dispute resolution. With the strategic mission firmly in place, the NLRC embarked on a far-reaching labor and employment agenda in previous years, furthering its efforts to be the preeminent government agency that has taken the lead in promoting and maintaining industrial peace based on social justice through economically viable dispute settlement machinery. In coordination with the DOLE, the NLRC is presently implementing the labor and employment agenda of President Ferdinand Romualdez Marcos Jr., which includes streamlined procedures, removal of red tape, restoration of integrity and fairness, and a much strengthened arbitration and adjudication system. While the NLRC's two core goals, disposition of labor and management disputes based on social justice and promotion, and maintenance of industrial peace, are earnestly being pursued, it continues to adopt innovative policies and practices, as well as landmark reform measures to ensure the achievement of these goals.
Since the creation of the NLRC, it has been persistent in pursuing reforms in labor and employment that will improve the services and address the problems in the labor adjudication process. The extensive campaign instituted by the NLRC in the past years, which has drawn support from both the public and private sectors, made its accomplishment possible. The National Labor Relations Commission was initially created on November 1, 1974, under Presidential Decree Number 442. The NLRC was created together with the regional arbitration branches. On March 21, 1989, the NLRC and the regional arbitration branches were reorganized pursuant to Republic Act Number 6715. Subsequently, on August 26, 2006, Republic Act Number 9347 created three additional divisions in the Commission proper and provided for the deployment of labor arbiters as reviewers at the regional arbitration branches. Republic Act Number 10741 was enacted on January 12, 2016 to strengthen the operations of the National Labor Relations Commission, amending the Articles 220 and 222 of Presidential Decree Number 442, otherwise known as the Labor Code of the Philippines.
The NLRC, through its regional arbitration branches, has jurisdiction over the following: the unfair labor practice cases, termination disputes, if accompanied with a claim for reinstatement, those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment, claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relations, and those cases arising from any violation of Article 264 of the Labor Code as amended, including questions involving the legality of strikes and lockouts, and all other claims arising from employer-employee relations, including those of persons in domestic or household service involving an amount exceeding 5,000 pesos, whether or not accompanied with a claim for reinstatement. Wage distortion dispute in unorganized establishments not voluntarily settled by the parties pursuant to the Republic Act Number 6727. Enforcement of compromise agreements when there is non-compliance by any of the parties pursuant to Article 227 of the Labor Code as amended. Money claims arising out of employer-employee relationship or by virtue of any by virtue of any law or contract involving Filipino workers for overseas deployment, including claims for actual, moral, exemplary, and other forms of damages, as provided by Section 10 of the Republic Act 8042, as amended by Republic Act Number 10022, and other cases as may be provided by law.
The Commission proper, on the other hand, has jurisdiction over cases decided by the labor arbiter, cases decided by the regional director or hearing officer on small money claims, cases of national interest certified by the Secretary of Labor, and petitions for injunctions or temporary restraining order under Article 225 of the Labor Code as amended. The nature of the proceeding in the NLRC is non-litigious in nature. As such, the proceedings before it are not bound by the technical niceties of the law and procedure and the rules obtaining in courts of law, as cited in Genuino Ice Company Incorporated versus Alfonso Magpantay with GR number 147790. Further, Article 227 of the Labor Code provides that in any proceeding before the Commission or any of the labor arbiter, the rules of evidence prevailing in courts of law or equity shall not be controlling, and it is the spirit and intention of the Code that the Commission and its members and the labor arbiters shall use every and all reasonable means to ascertain the facts in each case speedily and objectively, without regard to technicalities of law or procedure, all in the interest of due process. In any proceeding before the Commission or any labor arbiter, the parties may be represented by legal counsel, but it shall be the duty of the chairman, any commissioner, presiding commissioner, or any labor arbiter to exercise complete control of the proceedings at all stages.
In the case of Reno Foods Incorporated versus NLRC, GR number 116462, the Supreme Court has held that the quantum of evidence needed to establish a fact in cases filed before the NLRC is substantial evidence. Substantial evidence is such an amount of relevant evidence that a reasonable mind might accept as adequate to justify a conclusion. Further, the burden of proof rests upon the party who asserts the affirmative of an issue, as ruled in Jack C. Valencia v. Classic Vinyl Products Corporation, GR number 206390. Moreover, in the case of Angtibay versus the Court of Industrial Relations, GR number L-46496, the due process requirement in cases filed before the NLRC are identified as follows. Number 1, the right to present one's case and submit supporting evidence must observe. Number 2, the tribunal must consider the evidence presented. Number 3, the decision must have some basis to support itself. Number 4, there must be substantial evidence. Number 5, the decision must be rendered on the evidence presented at the hearing, or at least contained in the record and disclosed to the parties affected. Number 6, in arriving at a decision, the tribunal must have acted on its own consideration of the law and the facts of the controversy and must not have simply accepted the views of a subordinate. And lastly, number 7, the decision must be rendered in such a manner that respondent would know the reasons for it and the various issues involved.
An action in NLRC commences by filing a complaint in the Regional Arbitration Branch. It shall be signed under oath by the complainant or petitioner with a declaration of non-forum shopping. The case will then be raffled and assigned to a labor arbiter. The labor arbiter will issue summons within 2 days from the receipt of complaint or amended complaint. The service of summons shall be served personally upon the parties by the bailiff within 3 days from receipt. A motion to dismiss the complaint may be filed before the date set for the mandatory conciliation and mediation conference on the following grounds. First is the lack of jurisdiction over the subject matter, improper venue, res judicata, prescription, and forum shopping. The labor arbiter shall personally preside over and take full control of the proceedings. The labor arbiter will then direct the parties to submit simultaneously their verified position papers within 10 calendar days from the date of termination of the mandatory conciliation and mediation conference. Reply may be filed by any party within 10 days from receipt of the position paper of the adverse party.
The labor arbiter shall motu proprio determine whether there is a need for a hearing or a clarificatory conference. The labor arbiter shall render a decision within 30 calendar days without extension after the submission of the case by the parties for decision, even in the absence of stenographic notes. For cases concerning overseas Filipino workers, the case shall be decided within 90 calendar days after the filing of the complaint. The decision must contain 1. The facts of the case, 2. The issues involved, 3. The applicable laws and rules, 4. The conclusions and the reasons therefor, and 5. Specific remedy or relief granted. In cases involving monetary awards, the decisions or orders of the labor arbiter shall contain the amount awarded.
An appeal to the NLRC may be filed within 10 calendar days from receipt of the decision or order. The appeal shall be filed with the Regional Arbitration Branch of Origin. Take note that the NLRC decision is unappealable. However, the remedy is a petition for certiorari under Rule 65 of the Rules of Court. The petition should be filed not later than 60 days from the notice of judgment, order, or resolution before the Court of Appeals on the following grounds. Number 1, grave abuse of discretion amounting to lack or excess of jurisdiction. And number 2, question of facts or law.
Subsequently, the decision of the Court of Appeals may be appealed before the Supreme Court under Rule 45 of the Rules of Court within 15 days from the notice of the judgment or final or resolution on the ground of pure questions of law. And here is a sample complaint sheet template which one may use to file a complaint before the NLRC.